Okay, Part 1, Section 3, The Curse of Co-Suretyship, Why You're Held Accountable for the National Debt. In 1989, Austin Gary Cooper was prosecuted by the Department of Justice in United States District Court for, quotes, failure to file an income tax return. So this is the United States of America versus Austin Gary Cooper, and there's the case number from the Southern District of Florida. In this otherwise ordinary tax case, Cooper elicited a staggering disclosure from the judge that there are simultaneously two citizenships, citizen of the United States and American citizen. Quoting from the case, Cooper says, "I want a judicial determination. Am I an American citizen or a citizen of the United States?" Judge Hovler, "You are both." The Department of Justice prosecutor, Linda Kloslowski, an assistant United States attorney, in her closing argument revealed that United States citizenship is based strictly on contract. Referencing Austin Gary Cooper, the prosecutor revealed, Kloslowski, "He pays Social Security and he uses the Postal Service. Therefore, Mr. Cooper, all caps, is a U.S. citizen." Kloslowski divulged that the payment of Social Security taxes and the use of United States Postal Service constituted contracts of co-suretyship, note, not co-debtor, that rendered Cooper and anyone else so contracting under federal jurisdiction and a subject of mandatory federal income taxation. Surety is defined as, from Black's Law 7th edition, a person who is primarily liable for the payment of another's debt or the performance of another's obligation. A co-surety is a surety who shares the cost of suretyship obligations with another or others. Assistant United States Attorney Kloslowski asserted and Kloslowski's assertions revealed that any who pay into Social Security and use the Postal Service are considered mutually legally liable as co-sureties for the debt of the United States, for example, the national debt, that is to say, and thereby obligated to pay income tax. Flesh and blood men and women born in one of the 50 several states are American citizens, a standing acquired by birth. Their official alter ego or trade name is the citizen of the United States, a status acquired via contract. Judge Hovler also acknowledged that there are other media other than doing business with Social Security and the Postal Service by which American citizens regularly contract into becoming a citizen of the United States, but declining comment further. Okay, so let's read these definitions. Suretyship, the legal relation that arises when one party assumes liability for a debt, default, or other failing of the second party. The liability of both parties begins simultaneously. In other words, under a contract of suretyship, a surety becomes a party to the principal obligation. It's the 7th edition. Okay, under Black's Law, 7th edition, co-suretyship means suretyship with other sureties reference the same principal obligations. The national debt is the financial obligation of the U.S. government claimed by the Federal Reserve Bank and is based on the use of the Fed's private property, the valueless and unredeemable Federal Reserve notes as currency. All right, next section. The Act of July 27th, 1868. The Cooper judge's comments are in harmony with the legislation passed in the United States Congress formally acknowledging American citizenship and providing for expatriation of American citizens from other citizenships they may hold. Quotes, an act concerning the rights of American citizens in foreign states. be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that any declaration, instruction, order, or decision of any offices or any officers of this government which denies, restricts, impairs, or questions the right of expatriation is hereby declared inconsistent with the fundamental principles of this government. That's the United States Statutes at Large, Volume 15, Chapter 249, page 223, 40th Congress, July 27, 1868. The language used by the 40th Congress unequivocally specifies American citizens in foreign states, close quotes, rather than in foreign countries. What then is the special significance, if any, of a foreign state over a foreign country? So, what is the difference between a foreign state versus a foreign country? Consulting the Constitution of the United States of America, Article 1, Section 8, Clause 17, we find the geographical limits and realm of the political authority of the United States government. Quotes, the Congress shall have the power to exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square, as may by the cession of particular states and the acceptance of Congress become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Looking further into the Constitution, Article 4, Section 4 reveals a political distinction between United States and the several states. The United States shall guarantee to every state in this union a republican form of government. Further, 19 Corpus Juris Secundum 541, year 1990, spells it out even more clearly. Quotes, the United States government is a foreign corporation with respect to a state. As shown above, it is readily discernible from this simple examination of the Constitution and Corpus Juris Secundum that the 50 several states are foreign states in respect of United States, which exists only within the district not exceeding 10 miles square of Washington, D.C. This fact is echoed very unambiguously in the Uniform Commercial Code, hereinafter UCC. Quotes, location of United States. The United States is located in the District of Columbia. If you guys check out Google Maps, you'll actually see that 10 mile square highlighted and outlined, and that's pretty cool. The 50 several states of the Union, therefore, may rightly be considered as foreign states in the above excerpt from the Act, setting forth the stance of the U.S. government in reference to expatriation of American citizens in foreign states. Okay, next section. Quotes, corporate, unquote, citizenship. Corporate citizenship. 2.5 years after the Act of July 27, 1868, the U.S. government went into business as a for-profit municipal corporation on February 24, 1871. It is interesting that the quarterly list of expatriates is now officially entered into the Federal Register, quotes, a legal newspaper published every business day, unquote, according to its literature by a non-U.S. government company, the Internal Revenue Service, or the IRS. IRS, a commercial business whose two greatest expenses are postage and rent, as government agencies do not pay postage and rent, is an intelligence gathering, accounting, and collection agency for the private Federal Reserve and is domiciled in Puerto Rico under the Secretary of Treasury of Puerto Rico, also known as Secretary of the Treasury. who is also governor of the World Bank and governor of the International Monetary Fund, that's the IMF, both of which are headquartered in Washington, D.C. The secretary is also in charge of all the private bank paper, that is to say, Federal Reserve notes or FRNs, of his Federal Reserve employers and employs the full might of the Department of the Treasury, another non-U.S. government private business, in monitoring every institution / corporation / business / individual that deals in Federal Reserve notes. There is abundant evidence that the United States, that U.S. citizenship, is actually corporate citizenship, as well as being under the ultimate control of a private business, that is the IRS. As described above, the official list of parties who have renounced U.S. citizenship also includes a corporation, RBC Reinsurance of Canada. RBC Reinsurance and renounced its U.S. citizenship in the second quarter of the year 2000. Since this artificial person corporation is listed as an expatriate, it can be reasonably assumed that RBC Reinsurance at one time immigrated and became a, quote, citizen of the United States. Based on this and other revelatory facts, it may be safely surmised that the only type of entity that can ever become a citizen of the United States is an artificial person. Checking the spelling of the name of your passport, driver's license, sales permits, credit cards, certificates of title, etc., you will discover that the name imprinted thereon is written in all capital letters, the standard method for designating the name of corporations and corporately colored entities, which practice also falls completely outside the accepted rules of English grammar for the spelling of proper names of men and women. An all-caps name designates an artificial person, that is to say, corporation or corporately colored entity. Further, the prosecutor in the Cooper case, confirmed in open court that U.S. citizenship is based on contract rather than the situs of one's birth. One of the 50 several states, for example, the judge in the Cooper case also admitted of two different types of citizenship simultaneously, American and U.S. It can therefore be reasonably concluded that U.S. citizenship is indeed some kind of corporately colored citizenship, and that American citizenship is held by men and women and boys and girls born in one of the 50 several states. Okay, let's read through this real quick. Okay, the Legislative Act of February 21st, 1871, Congressional Records, chartered a federal company entitled United States. Does it say, quotes, United States, aka U.S. Incorporated, a commercial agency originally designated as Washington, D.C., in accordance with the so-called 14th Amendment, which the record indicates was never ratified. See Utah Supreme Court cases, Diet versus Turner in 1968, and there's all your citations there. Okay, the IRS was officially disclaimed as an agency of the United States government by the United States Attorney Betty H. Richardson on November 18, 1993. For a certified copy of the document, see U.S. Attorney disclaims IRS as agency of U.S. government. Okay, RBC is Royal Bank of Canada. Okay, so RBC Reinsurance. For complete expatriation list, see this website here, www.frisell.com/taxpat/taxpats .html situs is site, situation, or place. Okay. Next section. The nature of Social Security. A primary method by which United States contracts with its customers, quotes, is through Social Security and the payment of payroll taxes. Briefly, taxes are levied upon the debt of United States, as Congress, in favor of the private Federal Reserve Bank. President Franklin Delano Roosevelt and the United States Congress, after declaring bankruptcy, contracted with international banker owners of the Fed, who caused the bankruptcy by swindling America's gold, for, quotes, loans of credit, that is to say, money created out of thin air, presented as a New Deal. Okay. Another cash cow, other than personal tax income, was needed to saddle the American people with joint responsibility, that is to say, co-suretyship obligations, for the trillions of dollars in interest charges that would be generated courteous of the presidential/congressional treachery. The Social Security system, with Social Security payroll taxes, was devised for this purpose. The Social Security contract is essentially an unconscionable bargain because it binds every account holder for the stratospheric debt of the U.S. government. In the landmark 1937 case, Helvering versus Davis, and there's your citation there, the U.S. Supreme Court ruled that Social Security is a form of welfare. Quotes, the scheme of old age benefits created by Title II of the Social Security Act of August 14, 1935, providing for the payment of such benefits and authorizing future appropriations to an account to be set up by the Treasury for such purpose, sufficient to provide for the contemplated benefits, is within the power of Congress to spend money in aid of the general welfare. Interesting. Because of this fact, application for and use of a Social Security account number is a tacit confession that one is so incompetent in managing his or her own affairs that he or she must appoint the U.S. government as his or her guardian and seek eligibility for welfare payments. Such status is also known by other names such as child of the state and ward of the court. Those who are incapable of caring for themselves, Social Security account holders and their surety, are subjects of the doctrine of parens patriae, defined as follows. Latin. Parent of his or her country. The state regarded as a sovereign, the state in its capacity as provider of protection to those unable to care for themselves. Black's 7th edition. Legally, acceptance of a benefit, that is to say, welfare, for example, welfare, the protection of the state, is the equivalent of acquisition of a legal right in exchange for a promise, albeit a tacit promise, but a promise nonetheless, without which all such benefit would not have been plausible. Consideration of a contract is a benefit to the party promising, or a loss or a detriment to the party to whom the promise is made, and the benefit as an element thereof means that the promiser has, in return for his promise, acquired some legal right to which he would not otherwise have been entitled. And there is Woolham versus Sizemore, and there is all of the Case citations. All right, let's read these down below. Virtually every government on earth is bankrupt to the same group of bankers. Okay. Unconscionable bargain is a contract which no man in his senses, not under delusion, would make on the other hand, and which no fair and honest man would accept on the other hand. That's Black's Laws Dictionary, 1st edition. Wards of the court, infants and persons of unsound mind. Okay. Moving along. Translation. The fact of having acquired a legal right, that is to say, welfare protection and protection of the state, is evidence that you must have made some kind of promise or pledge and responsibility for payment of the debt of the U.S. government in the beginning that facilitated its outcome and the enjoyment of such benefits, as well as mere eligibility for such benefit, such as retirement benefits. So, right to contributions from other payroll taxpayers discussed below. Legal proof that there is no such thing as a free lunch. This concept is spelled out particularly clearly in the 1960s U.S. Supreme Court case Fleming versus Nestor. Okay. 366 U.S. 603, legal edition, 1435, 80th Supreme Court, 1367, 1960. The right to Social Security benefits is, in a sense, earned, for the entire scheme rests on the legislative judgment that those who are in productive years were functioning members of the economy may justly call upon the economy in their later years for protection from the rigors of the poorhouse, as well as from the haunting fears that such a lot awaits them when journey's end is near. The reason the words right and earned appear in the quotes within the above passage is because there is no guaranteed right in the Social Security benefits, and nothing is actually earned, that is to say, no vested interest. So that's Fleming versus Nestor. Here's another quote. To engraft upon the Social Security system a concept of accrued property rights would deprive it of the flexibility and boldness in adjustment to ever-changing conditions which it demands. Notice in the Fleming site that former functioning members of the economy can only call upon that economy other than active Social Security payroll taxpayers at the time of retirement for protection from the rigors of the poorhouse. That is to say, retirees can only hope that the economy will support them. Yeah, so it pretty much is my Social Security payments paying all the old people and not an investment I make in myself for later years. Because Social Security does not have to and may decide against it. Okay. As documented below, the so-called economy cannot provide Social Security benefits for anyone born after 1970, and the vast majority of others born before then will receive only partial benefits. Nobody has any accrued property rights, that is to say, no vested interest and no guaranteed requirement benefits, by virtue of paying Social Security payroll taxes as attested in Carley and Hamilton versus Snook. And that's 281 United States 66th, and Knight versus Jackson 260 United States 12th and 15th, and Nashville. And there's all your stuff there. Okay, here's a couple quotes. The constitutional power to levy taxes does not depend upon the enjoyment by the taxpayer of any special benefit from the use of the proceeds raised by taxation. Payment of Social Security benefits from the Social Security system is strictly discretionary, not obligatory. Thus, by law and by contract, when a Social Security payroll taxpayer retires, FICA and the Social Security system is not required to compensate the retiree or the Social Security payroll taxpayer. Another reason why Social Security is an unconscionable bargain. So FICA is Federal Insurance Contribution Acts. On every pay stub of a payroll check, you will find the term FICA, and that stands for Federal Insurance Contributions Act. This title is misleading for more than one reason. The word insurance in the title does not involve any insurance policy for the party paying the taxes. As stated above in Fleming versus Nestor, a Social Security payroll taxpayer has no vested interest in Social Security. If there were a valid insurance contract in the name of the party paying the premiums, then the party would have a vested interest in the contract, but such is not the case. For payments are taxes, not premiums. Rather, the insurance part of the title means federal insurance, that is to say, insurance for the federal government's debt in favor of the Federal Reserve Bank. Oh. Okay, the word contributions in the title of the Act, this word does not mean what most people think it means. In legal matters, the term has only one connotation, as demonstrated by the following definitions of contribution. Here's Bouvier's 6th edition. When two or more persons jointly owe a debt, and one is compelled to pay the whole of it, the others are bound to indemnify him for the payment of their shares. This indemnity is called a contribution. Here's another one from Bouvier's 6th. When one of several debtors pays a debt, the creditor is bound in conscience, if not by contract, to give to the party paying the debt all his remedies against the other debtors. Here's one from Bouvier's 8th edition. A right to contribution exists in the case of debtors who owe a debt jointly, which has been collected by one of them. Therefore, in the Act's title, Federal Insurance Contributions Act, contributions is not referencing the Social Security payroll taxes that are paid in by the taxpayer, but rather the nebulous right of the taxpayer to receive contributions or reimbursement from other taxpayers or co-debtors of their surety upon retirement after having paid off his or her entire fair share of the U.S. government's debt with a lifetime of labor. Without ever revealing the fact, what the Social Security scheme provides the retiring Social Security payroll taxpayer is the right to assert and expect and hope that other taxpayers who have not yet fully paid their fair share, quotes, by working and paying over a lifetime, will at least reimburse him or her with the meager stipend necessary for minimum survival in exchange for his 40-year attempt at the paying of national debt, mathematical impossibility. Chance that the average taxpayer will ever recover the full amount paid in over the work years, 0%. So in my particular life, let's say I'm earning like $15 an hour. If I pay, I think it's 12% into Social Security, that would be about, I think, a little over $30,000. Let's say I'm 30 years old now. So if I'm going to work another 30 years, that's about, give or take, a little over $30,000. Instead of paying that into Social Security, it'd probably be better if I invested it in stocks and bonds or other places. So maybe this will tell us how to get out of that. The second Bouvier's let's move along. The second Bouvier's definition of contributions above reveals the position of the federal government in this most masterful of confidence games. All right, first one. When one of the debtors pays a debt, once a debtor has paid Social Security payroll taxes for a lifetime, that debtor has paid off all of the debt that he or she is physically capable of paying their fair share. Yeah. Okay, the creditor is bound by conscience, if not by contract. That means the creditor, the U.S. government, actually the Federal Reserve, the U.S. government is a straw man for the Fed creditors, though having no contractual obligation to give the retiring taxpayer any form of compensation, is at least morally obligated as follows: to give to the party paying the debt all his remedies against the other debtors. Means the U.S. government is morally obligated to assist the retiring co-surety Social Security payroll taxpayers or debtors in acquiring reimbursement from other co-surety and Social Security payroll taxpayers, debtors currently paying taxes. The U.S. government thereby fulfills its moral obligation with retirees and defrauds all current Social Security payroll taxpayers by number 1, collecting payroll taxpayers from current taxpayers, and number 2, dispersing payment benefits to retirees out of current collections, and number 3, pocketing the difference. Whereas most people believe that surplus collections go into a trust fund in their name, the ugly truth is that Big Brother's commandeers the funds for its own purposes. This is the precise reason that Social Security system will be legally insolvent around the year 2016. Yeah, it's pretty bankrupt right now. The IRS and the U.S. government and Federal Reserve has zero and legal or contractual obligation towards the Social Security payroll taxpayers. And when current payments exceed current collections in 2016, the beginning of the end will be real for all. The above is confirmed in newspaper articles like the one below that appeared in the August 1st, 2001 edition of the Los Angeles Times, entitled Change of Heart Sought on Social Security Plan. Articles like this keep massaging us with little reminders that Social Security income /outgo lines will cross in the year 2016, and the so-called trust fund will be exhausted in the year 2038. Quote, Social Security faces increased financial strains as the baby boom generation, born from 1960 to 1964, begins to retire in about a decade. By 2016, the program will begin paying out more in benefits than it collects in taxes, and by 2038, the trust fund will be exhausted. If any so-called trust fund existed, where Social Security payroll tax money was held in trust in the name of the party who paid in the taxes, the trust fund could never be depleted and the system could never go bust. People spend 30, 40, and sometimes 50 years of their life paying money into their so-called Social Security account. Upon retirement, they begin receiving, on a monthly basis, only a microscopic portion of the total amount paid in over their lifetime. If these funds were held in a trust on their behalf and accounted for in their name, how could the funds ever disappear? The reason people can and will be denied Social Security benefits is because payroll taxes are just that, taxes collected by IRS, a tax collection agency. No one has any right to enjoy any special benefit from funds raised through taxation, as cited above. Such unrestricted perfidy, deceit, and treachery will not go unnoticed much longer, however. The exhaustion point mentioned in the above article is informing us of the end of the shock absorber fund. That is to say, those funds especially allocated for the winding down period, when large numbers of people begin figuring out that they have been conned. Spread over a 22-year stretch, however, taxpayer outrage should be fairly well dissipated enough, probably for avoiding mass insurrection against those in charge. Alright, next section, the Ponzi scheme. Most people are familiar with the pyramid schemes and chain letters. These are each a breed of Ponzi scheme in which people who mistakenly believe themselves investors are actually only suckers making donations for the organizers of the con. Alright, let's figure out what a Ponzi scheme is from Black's Seventh Law. Alright, Ponzi, a fraudulent investment scheme in which money contributed by later investors generates artificially high dividends for the original investors, whose example attracts even larger investments. Money from the new investors is used directly to repay or pay interest to old investors, usually without any operation or revenue producing activity other than continually raising of new funds. This scheme takes from Charles Ponzi, who in the late 1920s was convicted for fraudulent schemes he conducted in Boston. Okay, this definition is echoed in a December 15, 2001 article in the Los Angeles Times entitled, quotes, "Investments Called Long-Time Schemes," unquote, wherein an alleged Ponzi scheme is dissected. One line from the article reads as follows, quote, "Most of the payments were actually money taken from other investors, a classic Ponzi scheme." Per the definition of Black Seventh, and as confirmed in the article in the LA Times, the Social Security payroll taxation/benefit program meets all qualifications of a Ponzi scheme. The first one is retirees and other Social Security benefits recipients, the original investors, get a full payout of Social Security benefits as expected. They receive artificially high dividends compared with those who will get little to nothing. Second, people who are paying Social Security payroll taxes now, that is the later investors, face no hope of receiving Social Security benefits or a full payout because as of 2016, 100% of Social Security payroll taxes collected will be absorbed by retirees or old investors. And even retirees will be shortened because of the deficits. And third, there is no other legitimate revenue producing activity for ensuring that current taxpayers and the new investors will get anything. In a Ponzi scheme, usually the only outgoing activity is the raising of more funds from new victims. Except for the pittance that has been earmarked for the winding down period from 2016 through 2038. The only thing going on with Social Security is the continuous extortion of payroll taxes from those who are presently working, as to say the new investors. All right, next section. Your DC politicians explain it all for you. Okay, from the July 20th, 2001 edition of the LA Times, an article entitled "The System is Broken," Social Security panel declares, quote, "The system is broken," declared the Commission's co-chairman, former Democratic Senator Daniel Patrick Moynihan of New York and Richard D. Parsons, Chief Operating Officer of AOL Time Warner, in the report's preface. But is it really true? 6 weeks later, an esteemed colleague of Moynihan, Pete versus Domenici of New Mexico, apparently disagreed in a September 7, 2001 article in the LA Times. Domenici bucks GOP's policy, says tap Social Security surplus. Domenices cites huge surpluses in Social Security rather than impending doom. Quote, Washington, Senator Pete versus Domenici of New Mexico. The top Republicans on the Senate Budget Committee broke ranks with his party Thursday over the politically sensitive issue of the Social Security surplus, saying that he saw no reason in the world why those funds should not be used for education or defense spending next year. Virtually all of the surplus in 2002 will derive from Social Security payroll taxes paid by individuals. With huge surpluses of the last several years, these funds have been used mainly to reduce national debt. Riddle me this, Batman. If there have been huge surpluses in recent years, and the surplus every single year since the inception of Social Security in 1935, how could any so-called trust fund ever be exhausted, and how could the system now be, quotes, broken? If the system is broken today, then it was broken the day it was drawn up because nothing has changed, and the potential for disaster, such as the one now looming on the horizon, was a fait accompli from the gate. Social Security has done nothing but rake in taxes from the vast majority of American workers and the employees over the last 67 years and pay out benefits for the much tinier number of retirees and disabled Americans. What is happening with the trillions of Social Security payroll taxes collected in excess of the benefits being paid out? The mystery is resolved in the legal definition of the word surplus, which strategically appears within the Domenici article. Surplus is defined as the excess of receipts over disbursements. Okay, in Bouvier's sixth, that which is left over from the fund has been appropriated for a particular purpose, the remainder of a thing, the overplus, the residue. The only reason Social Security can be called broken and in trouble now for the first time in history is because surplus funds are skimmed and have been skimmed every year for the last 67 years, a built-in aspect of the program. As is noted in the Domenici article, excess funds go elsewhere, for example, for reducing the national debt, and do not accrue for the benefit of those paying the taxes. The entire racket is confessed by the Supreme Court in one sentence, if by omission, in Fleming versus Nestor. Quote, the Social Security system is a form of social insurance enacted pursuant to Congress's power to spend money in aid of the general welfare, whereby persons gainfully employed and those who employ them are taxed to permit the payment of benefits to the retired and disabled and their dependents. Comparing the foregoing Supreme Court explanation of Social Security in Fleming and the following Securities and Exchange Commission's allegations of the Ponzi scheme taken from the August 29, 1999 article in the Los Angeles Times entitled Two Oregon Firms Named in Payphone Ponzi Scheme. It is difficult to make any meaningful distinction between the two. Quote, the two grants Passor based companies defrauded as many as 7,000 people concentrated in California, Texas, and Florida by paying early investors, retired and disabled, from deposits of new investors, persons gainfully employed and those who employ them, rather than from investment returns, rather than returns derived from trust fund investments. The above Supreme Court quote from the Fleming case tells us that tax dollars collected in excess of what is needed for payment of benefits in any accounting period surplus are not part of the equation, and that there is no provision of benefit for those actually paying the taxes. People paying FICA payroll taxes are supporting those on Social Security welfare. However, nothing accrues for the benefit of those paying the taxes. Surpluses are swept away. Any first-year accounting student can tell you that once the retiree benefit dollars to be paid out outnumber worker payroll tax dollars that are collected, the system will not be capable of meeting its financial obligations in a condition known as insolvency or bankruptcy. This fact, also known the day the program was instigated in 1935, and based on the overwhelming pecuniary significance of such aspect, tens of trillions of dollars funneled out of Social Security, it cannot be regarded in any light other than intentional. All right, let's look at pecuniary. Pecuniary, of or relating to money. All right, guys, let's stop there for the moment, and then we'll start the second part of this section later.